Okay, good morning everyone. I hope I am audible and visible to all of you. So, today we have to discuss culpable homicide. Okay, so yesterday we discussed general exceptions, which are ranging from section 76 to basically 95. Okay, 76. The first exception, first general exception which we read about was 84, which is unsoundness of mind. Unsoundness. Then we discussed about, we had a brief discussion about unsoundness of mind, what it is and how it is, and how the accused basically gets this benefit of unsoundness if proved, and what happens once it is proved. He is sent to lunatic or basically at the prevention or detention center. Basically, he is detained, not convicted or jailed. Okay. So after that, we discussed about section 85, which was intoxication, having almost the same or the similar language, just difference, just and the only difference being that it talked about intoxication, or better to say involuntary intoxication. Okay. Involuntary intoxication. Thereafter, we went on to discuss intoxication as a defense, but if the act requires some specific kind of intent, particular intent in the language of Baat. If the offense requires a particular intent, then this defense is not available. So, yesterday one of you asked me, or basically requested me for an example or illustration of the same. So, today I will be giving the illustration. Suppose there is one A. Okay, he is intoxicated. That too involuntary. Involuntary intoxication was there. Okay, and he killed B. Now the manner in which A killed B is such that he gave a lathi blow, only one lathi blow to B. One lathi blow to B. Now, in ordinary course of nature, one lathi blow would not kill B. But since B was already suffering from a injury on head, and he was at the recovery stage only, he already had a injury on his head. Injury on his head. So A was aware of this fact that he had an injury on his head and he is at his recovery stage. And if he gives one lathi blow to B, then it will cause his death. So this is a situation wherein it requires a particular intent, as mentioned in section 86. That is, if he is intoxicated involuntarily, but the act which he is tried in the court requires a particular kind of intent, then he will not get the defense of intoxication. 86 denied. Okay. Then we read about section 76, act done by a person bound by law. Then we read about section 77, that is act of judge acting judicially. Okay. After this, we read about section 78, which talked about act done in pursuant of a judgment. Okay. Then section 79, person who thinks himself to be justified by law. Then section 80 talks about accident. Then section 81, necessity. We discussed the bridge example and the ship and the boat example. Then section 82, which is doli in capax, act done by a person below 7 years of age, that is child below 7 years. Then 83, child is above 7 but below 12. Here we see if he had the sufficient maturity of understanding to understand what, yes, to understand the nature or consequence of his act. Correct. Then 84 already done, 85, 86. Then after these sections, we straight away came to section 90 and discussed consent. Consent basically option. What is consent? Basically it is option. Option to accept or to reject. Okay. Then after discussing consent, we linked it with section 375, that too secondly, which says without consent. And we discussed an example also where a marriage happened in a village and a third person misrepresented himself as the husband of the wife or the lady and had sexual intercourse with him. The wife consented to him, believing him that he is the husband, but actually he was not the husband. So, in that a case, if that is the case, then it would not be a valid consent because the lady was acting under a misconception of fact. Hence, it was not a valid consent. And since it was not a valid consent, it would come within the definition of section 379. Secondly, that is act, the acts which are mentioned in section 375. Secondly, that is without consent. Hence, it would amount to rape. Okay. The the consent which we talked about, yeah, consent consent we talked about both. A consent which is induced by fear is also not a valid consent. A consent under misconception of fact, that is also not a valid consent. Okay. After this linkage was done, then we again came to general exception and we discussed section 87, which was voluntary non-fit injuria. And it talked about acts done with the consent when the victim consented to suffer harm. Then he would not be later on allowed to prosecute the accused that he had suffered some harm. But we had four exceptions to that also, which we discussed yesterday, which were related to death and grievous hurt. The reason of these exception is basically public policy, nothing else, as no person will consent to his death. So it is a matter of public policy that we have kept these uh, four, basically 4 to 5 kind of exceptions, that the doer is likely to cause death or grievous hurt, or if the doer intended to cause death or grievous hurt. If the doer had any of these four, then he would not get the defense of that the victim consented to it, and he will be convicted. Okay, then we discuss section 88, which was act not intended to cause death but done in good faith. Done in good faith with consent. Basically, it is for doctors. Then section 89, it also talked about act not intended to cause death, but here it talked about consent of child. So it would basically relate to consent of guardian of the child, not intended to cause death. Done for benefit of child. Okay, then we discussed section 90. No, we discussed section 90 earlier only. It related to consent, right? Then we discussed section 91. These are some of the acts which are offenses. Independently of harm caused. Independent of harm caused. Okay. Then we discuss section 92. It was act done act done act done in good faith without consent. Okay, then we discuss section 93. Section 93. Yeah, this is also available to doctors, and this talked about communication made in good faith, wherein we discussed the heart communication made in good faith. Here we discuss the heart patient example. Okay, then we discuss section 94. Section 94 basically prevents a person who was compelled by threat, but the same does not extend to a person who by himself went to the, or he himself went and undertook the threat, and thereafter he went as basically helped to commit the crime. So it does not extend to that person, it only extends to the person who did the act under threat. Here we discuss the Smith example or Chabiwala example. Okay, then we discuss section 95, and section 95 basically talked about trifling acts. And what are trifling acts? Trifling acts means the acts which a ordinary person would not consider of complaining. As in, the term used are a person of ordinary sense and temper. Okay, so these were the exceptions, and from section 96 it was private defense. We discussed these also, section 96 to 106 in quite detail, already discussed. Okay, now let's come to section 299, that is culpable homicide. We did not discuss much about culpable homicide yesterday, but yes, we completed general exceptions as well as private defense yesterday. Now we have to discuss culpable homicide today. So basically, culpable homicide is what? I tell you. It is made up of two words, that is culpable and homicide. Now, what do you mean by homicide and what do you mean by culpable? Homicide basically means death. And culpable means something which is punishable. Is punishable. Okay. So for death, we need a definition of death here. Okay. So for the definition of death, let's come to section 46. Let's read section 46. Yes. So section 46 talks about death. What does this mean? The word death denotes the death of a human being unless contrary appears from the context. Okay. So for the purpose of IPC, the term death means or denotes the death of a human being. Now, according to this, it means death of a human being. So, culpable homicide together forms or gives us this thing, death of a human being, which is punishable, makes culpable homicide. A homicide which is culpable homicide. Okay. Now, let's come to section 299. Anyone, what is the actus reus here? If anyone can tell me, actus reus, mens rea, tell me, what's the actus reus here? Yes, basically, actus reus is death, as it was in murder. We discussed in the example also. Here, mens rea will be intention of causing death. This is like if you read section 299, you will find three mens rea there. First one is intention to cause death, then intention to cause bodily injury. These are the three mens rea there. And third one is knowledge. I think there was some blackout kind of thing. Yeah. So we were discussing 299 and it basically tells us culpable homicide. Actus reus being death, mens rea is different. There are three mens rea. First one is intention to cause death. Second one is intention to cause bodily injury. And the third one way is knowledge that such bodily injury is likely to cause death. Okay, let's read section 299. Look, section 299, culpable homicide. Whoever causes death by doing an act. Look, whoever causes death by doing an act with the intention of causing death. Okay, then we have or with the intention of causing such bodily injury as is likely to cause death. Then we have or with the knowledge that he is likely by such act to cause death commits the offense of culpable homicide. Okay, so basically there are three parts in the definition. What are the three parts? This is the first one. This is the first one. Okay, then intention of causing bodily injury as is likely to cause death. This being the second one. Then or with the knowledge that he is likely by such act to cause death. This is the third part. Okay, basically section 299, first part, intention to cause death. And death read with section 46 means death of a human being. Then with the intention of causing bodily injury as is likely to cause death. First part, second part, third part. It talks about knowledge. Knowledge being the second degree of mens rea. I told you mens rea is of three types. Remember, intention, knowledge, reason to believe. Three types of mens rea I told you. Intention, knowledge, reason to believe. This is knowledge. Okay. Now let's discuss section 299 first part. That is intention to cause death. Okay. Now, what do you mean by intention to cause death? What will be the intention to cause death? Section 299 part 1 is the easiest one. Then we will have uh, basically discussion about section 299 part 2 and part 3. Today we will be discussing only section 299 and tomorrow we will discuss section 300. And I will tell you how these two sections are interrelated and how and in which cases culpable homicide does not amount to murder and in which cases culpable homicide amount to murder. Okay. And the culpability of the same. Like if culpable homicide amounts to murder, then what will be the culpability and under which section? And if culpable homicide does not amount to murder, then what will be the culpability and under which section? Okay, so see, in intention, the act of the accused will be more particular, as in he will be more particular about the act and he will be more particular about the consequence of the act, that his act or conduct will lead to the death of the accused. So this is the highest degree of mens rea. If someone has intention to do it, he will be more particular about as in everything. He will plan everything according to it. He will buy a gun according to it. He will as in plan whole of his line of event, that on this day he will plan the shooting, like he will before this actual day of shooting he will be practicing about the shooting. He will be making a whole site plan of the, maybe if the if he is a sniper, then he will be acquiring all the resources which are required. Maybe if he wants to shoot person B in a building, then he will find a building which is or from where his sight is clear and his gun or the bullet can reach directly to B and hit upon B, resulting in death of B. So This is the kind of this is the kind of mens rea they are talking about in section 299 part 1. That the it is the intention. If someone has the intention to do an act, then he will be acting with utmost care and caution, and he would be more particular about everything. So this is section 299 part 1. Okay, if anyone has any doubt, kindly let me know. Okay, an example. Okay, I'll give an example. Suppose there is A and we have B. A gave a lathi blow to B. Okay. Now suppose he gave a severe lathi blow. Instead, he gave 2-3 blows to B. Here we will say, now where did A hit? That is also that will also be examined. If A gave 2-3 lathi blows on the head, then in such a case there is like we would impute that A had the intention to cause death of B. If he gave only one lathi blow, then we will examine it under other circumstances. What were the surrounding circumstances? Okay, but if A gave 2-3 lathi blows on the head of B, then obviously he had the intention to cause death of B. Then only he will be giving 2-3 lathi blows to B. Okay, but at the same time, if this one was one lathi blow and it was given to C, suppose C, a child, maybe of 5 years. In this case, this one lathi blow only will tell us that A intended to cause death of the child, and intention was to cause death of C. Okay, so this was about intention to cause death. That is section 299 part 1. Now we have section 299 part 2. What does it tell us? Section 299 talks about intention to cause bodily injury, as is likely to cause death. Okay, so here what we will see is the intention of the accused to cause bodily injury. We will not see whether he had the intention to cause death. We will see whether he had the intention to cause that bodily injury. And thereafter, like part 2 can also be divided into two if we come to examination stage. If we examine it, if we will be examining it very carefully, then we'll come to know that section 299 part 2 can also be examined into, can also be divided into two. And here what we will see is the intention of the accused to cause the particular or the specific bodily injury. Then thereafter we will see whether that bodily injury as was inflicted by the accused is likely to cause death. Now this thing is mainly or generally is done by medical reports or medical experts. They are being called into the courts and they are asked that whether the bodily injury which is inflicted upon the victim is enough. Medical examination of victim. Now is enough to cause death of the victim. And it, one more thing has to be, which has to be seen is, it has to be seen that the bodily injury which was inflicted, it was because of this bodily injury and this only, because of this bodily injury only the death of the victim was caused. If the death of the victim was caused due to any other thing, then we won't be saying that the person is liable for culpable homicide. And if he is not liable for culpable homicide, then he won't be liable for murder. I will discuss it tomorrow. Okay. So if you have not understood this, kindly let me know. Okay, I'll give an example also. I'll give an example here also. Suppose a lathi blow to B. One lathi blow. Okay. Now this is a bodily injury. B being a person of 20 to 25 years. Now you tell me whether one lathi blow is enough to cause death of a person. Very simple. No. In most of the cases, the answer will be no. Right? Now suppose A here A gave 2-3 blows. That too on head. Here also it will be bodily injury. Okay. Now if you are giving 2-3 lathi blows and suppose this lathi was of instead of lathi it was an iron rod. Okay. Instead of lathi it was an iron rod. Now this blow with an iron rod, that to 2 to 3 blows with an iron rod on the head of a person, in our case B, this bodily injury is obviously likely to cause death. Even if we call doctor's opinion, he would say that the injuries are such that that they are likely to cause death. Doctor's opinion would also suggest the same, that these bodily injuries are likely to cause death. Okay, understood. Now, let's come to section 299, part 3. What does section 299, part 3 tell us? Knowledge that act, knowledge that he is likely by such act. Okay, here bodily injury is not being talked about. They are not talking about bodily injury. They are just talking about act. And when they talk about act, it will include omissions also. Read with section 32 will include illegal omissions also. Okay, understood. Now, if you have any doubt, kindly ask me. Okay, you need an example. Okay, I'll give an example. Again, lathi blow example. Lathi blow to B. Suppose he gave only one lathi blow here also. This time not with iron rod. It was a lathi blow. Suppose section 299 part 1, that is intention, is not true. Then section 299 part 2, that is also not true. Now section 299 part 3, what does it require? It requires only knowledge. See, Here only knowledge is required. Okay. Now here what will we examine? Is one lathi blow? Rather we will examine, was A aware that, or A had the knowledge that his act is likely to cause death of B. In section 299 part 3, we will only examine knowledge. Okay. Knowledge of whether the accused had the knowledge that his act is likely to cause death. Okay, that's all. So section 299 part 1, intention, requires higher degree of mens rea. In section part 2 of section 299, we just examine whether the accused had the intention to cause that bodily injury. Now, once once it is established that he had the intention to cause the bodily injury, then we examine whether that bodily injury is likely to cause death. And this is done by doctor or medical experts. Once this is proved, then we say the accused has committed culpable homicide. Section 299. Okay, see how you will examine an act. How examination of the act will be done. First, always see if part 1 applies. Part 1 of 299. Always see whether 299 part 1 applies. That is intention. If you are able to prove this, then it is the best situation, because this is a situation when you read murder, that is section 300, you will come to know this is the best situation. for a lawyer, because once section 299 part 1 is proved, then it will directly fall in section 300, and murder will also be proved. I'll explain it tomorrow. So then examine section 299 part 2. This only will be examined if there is a bodily injury. If there is no bodily injury on the accused, then don't don't examine section 299 part 2. Straight away come to section 299 part 3. Okay, suppose a a got a snake, that too a poisonous one, and he made the snake bit B. B as a result died. So here section 299 part 2 will not apply because there is no bodily injury. Okay, if section 299 part 2 does not apply, then obviously this, if you are getting someone bit by a snake, then this is an act wherein your intention is that it should cause the death of the person. Okay, so intention is clearly established here. Section 299 part 1 directly will be proved. No need to come to section 299 part 2. Okay, but even if this fails, suppose for some reason this charge or this contention or section 299 part 1 fails, you are not able to establish section 299 part 1, then come to section 299 part 3, that is knowledge. Knowledge that such act is likely to cause death. Now here the burden of proof is much less as compared to section 299 part 1, likely to cause death. Okay, so that's how we go in a in case of a, if we wish to prove culpable homicide or murder. Okay, now let's read the definition of section 300 or murder once. Thereafter we will wind up. Murder, section 300, except in the cases hereinafter accepted. They mentioned hereinafter. Remember this. Hereinafter accepted. Culpable homicide is murder. Culpable homicide is murder. If the act by which the death is caused is done with the intention of causing death. So what are they talking about here? They are basically talking about section 299 part 1 only. If the act by which the death is caused is done with the intention of causing death. Whoever causes death by doing an act with the intention of causing death. Same thing. So if section 299 part 1 is proved, then automatically it falls under section 301. They have not mentioned one here, but it is because in look from here they have mentioned secondly, thirdly, and fourthly. They mentioned four situations wherein culpable homicide is murder. So except the cases which are accepted here, apart from these cases, culpable homicide will be murder. Here is from here exceptions start. Exception 1, when culpable homicide is not murder. Okay, these are the exceptions are not these are not the exceptions. Secondly, thirdly, fourthly, these are the instances or the cases wherein if culpable homicide is done plus something additional, that is any of these secondly, thirdly, and fourthly is also proved, then it will fall under murder. Then it will be section 300. From section 299 it will come to section 300 directly. Okay. Look, firstly, whenever there is a charge maybe of murder, firstly the prosecution has to prove culpable homicide. Only if they are able to prove culpable homicide, then they can go into murder. Suppose this is the so case always starts from culpable homicide and then goes into murder. Always. First culpable homicide is proved, then in addition to any of those, if section 299 part 1 is proved, then directly murder is proved, 300 part 1. But if secondly, thirdly, if second and third part are proved, then we have to prove here something more in order to get the accused conviction under murder, and conviction under murder means section 302. Okay, so let's wind up the session of today. Thereafter, maybe in tomorrow's class, we'll be summing up this topic of culpable homicide and murder. And thereafter, we will be left with kidnapping and then adultery. Okay. So these are the topics which are left for your session. Now you all may start leaving. Thank you. We'll discuss rest of the things later or maybe tomorrow. If you have any other doubts, you may ask me. Otherwise, you may leave.